Good day, ladies and gentlemen. Thank you for tuning in on this presentation on the topic of cross-border obstacles to text mining projects. This presentation is part of a panel entitled Legal and Economic Issues in Data Mining. My name is Lucie Guibault. I am Professor of Intellectual Property Law at Dalhousie University, and I wish to thank the organizers of this workshop. So today's topic is cross-border obstacles to text mining projects. We're not dealing with mining activities in quarries or deep bed sea mining activities. We're dealing with mining of texts and scholarly literature. The link perhaps may be useful because text mining is one of the most modern tools of doing research that allows scientists to query vast amounts of text in search of new insights. So, for example, if you're looking for insights on the environmental impact of coal mining, then you may look at vast amounts of literature and trying to find new insights and new knowledge and understand better how over the years, the coal mining industry has impacted the environment. So what is text and data mining? TDM, for short, is a discovery by computer of new previously unknown information by automatically extracting and relating information from different resources to reveal otherwise hidden meanings. You have a cloud of interactions which all involve machine learning and text mining, which involve information retrieval and search, machine learning, natural language processing, and all the activities surrounding this, which generates, therefore, new information, new knowledge. So if you go back to the coal mining industry and trying to find out what the environmental impact of the coal mining industry, you may of course look at data and you may look at measurements, but you may also look at what authors have said and written over the years, and you may look at a vast amount of literature on the topic. You have tools and websites set up to make the scientist's life easier. One of those is the semanticscholar.org website. It contains thousands of articles on different topics in different disciplines and allows scientists to go query those sources in order, indeed, to generate new knowledge. As you see on the screenshot, I just typed in coal mining in the category of geology, and you can already find the top 5 or 6 articles on the topic. Semantic Scholar is partner with a number of institutes and organizations and publishers that you see on slide 6. Among them is PubMed in the medical science, but it's also Springer Nature, the Royal Society, Taylor Francis, and a number of publishers. So what's the question? The question is that when a scientist engages in text mining activities, to do so, most of the time, the scientist will need to make a reproduction of the corpus of text into his own machine in order to query that corpus and generate new insights. Now, if all those articles are still protected by copyright, which they mostly are, this may involve a copyright infringement. 7. So the question I ask is, what does copyright law do or imply on cross-border text mining projects? Does it support or does it stifle those activities? What you need to realize is that copyright law is determined at a national level. So although there is a lot of harmonization internationally through the signature of international treaties on the topic of copyright, copyright law is still primarily a national regulation. The scope of protection is determined by each country, which means that in some countries, text mining activities may be lawful, and in others it may not. So this is where we ask, does copyright law support or stifle cross-border mining projects? In the countries of the European Union, an express text mining exception was adopted in the 2019 Directive on Copyright in the Digital Single Market. And this is the topic of Professor Thomas Margoni's presentation on the same panel. You may also know that in Japan there is also an express copyright exception allowing for text mining activities to take place without prior authorization of the rights owner. This is the situation in the European Union and in Japan. In countries like the United States and Canada and other countries of the Commonwealth, the Copyright Act contains what we know as the fair use or fair dealing defense, which is, as the name suggests, a defense to a copyright infringement claim. And this is the topic of Professor Mike Carroll's presentation in the same panel. Professor Carroll will probably have explained that in the United States, some courts have interpreted the fair use defense as probably including activities of text and data mining. So what constitutes a fair use will be judged by the courts following four main factors, including the nature of the work copied, the amount of work reproduced, the purpose, and the impact on the market of the original work. So you can imagine in many instances, text mining activities may not have an impact on the original work and will probably qualify as a fair use. Now, that's the situation in the United States. In Canada, the Supreme Court has rendered several decisions concerning the fair dealing defense, and in cases dealing with research purposes has usually ruled that the purpose of research should be interpreted broadly. And therefore, examining the fair dealing defense and the cases at hand, in the cases that were brought to the Supreme Court of Canada, in many instances the court has decided in favor of the user. And also in a famous case of 2004, the Supreme Court declared in the CCH case that fair dealing is a user's right that should be given the same strength or weight as the author's rights. This gives to think that text mining activities in Canada probably would qualify as a fair dealing. Now, the issue is how do you manage, or how do the conditions set in the European exception in the 2019 directive, how do they coincide or not with the fair dealing defense or fair use defense? And how can researchers on both sides of the Atlantic deal with the reciprocal conditions of using vast amounts of text to engage in text mining projects? That's a first question. The second question is, what about other countries? If you're an author or a researcher in a Latin American country or in Africa or in other countries outside of Europe, Canada, and the United States, what can you do? That's a question that we will see in a few seconds. So, as Professor Margoni probably has explained, the European exception puts certain conditions on the exercise of the text and data mining exception. One of the main exception, or condition, is that the research or the text mining activity should be carried out by someone employed by a research organization. A research organization is defined elsewhere in the European legal framework, but usually includes not-for-profit institutions such as hospitals, universities, and other institutions where research takes place. The exception also applies to research being carried out by cultural heritage institutions or in the context of cultural heritage institutions' activities, but it does not include commercial companies. So if you're an employee of a pharmaceutical company or a coal mining company or any other type of industrial partner, you will probably not be eligible to benefit from the exception under the European acquis. On the other hand, if you're located in the United States, mainly the fair use exception would look at the quality of the person using the works as one of the 4 factors to determine whether we're in a situation of fair use or not. So it would not be as such a requirement to disqualify the user. It would be only one of the factors. One of the requirements of the European directive also says that copies may be retained of the data sets for further verification. So this is to be determined at a national level. You can expect that countries will not necessarily have the same approach to the retention of copies of data sets, which may create problem also within the member states of the European Union for researchers who also collaborate with other researchers across the EU. So when can you retain data and when can you not? That will be determined at a national level. Another requirement is that the copies of the data sets can only be made from lawful sources. So what qualifies as a lawful source would also be determined, I guess, by through jurisprudence and most probably at the national level. How does this compare with the United States? Well, the lawfulness of the copy is not necessarily a factor autonomous in the assessment of the fair use exception, or in Canada of the fair dealing exception. So we will need to see how courts react if text mining activity takes place with more or less lawful sources. So finally, under the EU directive, text mining for commercial purposes would be allowed under Article 4 of the directive, but only if rights have not been expressly reserved. So if we go back to the slide number 6, which lists a number of partners of the semantic scholar, if those publishers or organizations reserve their rights on the web page in any form, this may prevent a commercial user like a pharmaceutical company or like a mining company from engaging in text mining activities with their works. So the limits on cross-border projects is that in the vast majority of countries around the world, especially in South America and Africa, where the copyright acts are more restrictive and provisions are interpreted if they reach the courts in a restrictive manner, means basically that making a copy of the articles or dataset would most probably be a copyright infringement even if made for research purposes, because usually if there is an exception to cover research activities, it is usually too narrow to cover the reproduction of vast amounts of articles for the purposes of text mining. And retaining copies and publishing results would most probably also be problematic in those countries. We also need to take account of the fact that most data sets or most collections of articles are usually put online following contractual restrictions. So contractual restrictions are likely to play a role in how researchers approach a text mining project. There is a wide range of contractual terms out there, from very restrictive to open. So it will depend on the specific terms and conditions of use of a particular set to know whether a scientist can use or not the corpus. So what are the consequences for cross-border projects? Well, they can be important because in most countries, copyright law creates a chilling effect on researchers and their institutions who will refrain from conducting text mining research because of the uncertainty in the law, because of the fact that in many countries around the world, the law is too narrow to recognize the possibility to engage in text mining. Therefore, researchers who are often risk-averse will refrain from engaging in such activities. Or researchers might shop for the most convenient location to carry out the research. There are instances where, before the adoption of the European Directive in 2019, some European researchers would seek partnership with American collaborators to be able to benefit from the more flexible interpretation of the fair use defense. Now the European researchers don't need necessarily to seek American counterparts because the law does give them a bit more leeway, but they still need to deal with the requirements in their act. So forum shopping for most convenient location may certainly happen. In most countries, researchers will need to obtain permission from the rights owners, and research projects will be delayed and costs will be increased as a result of all that. And when we think of the COVID pandemic situation, such delays may mean lives. So thank you very much for your interest in this presentation. And if you have any questions, please do not hesitate to email me. Thank you very much.